Thank you for joining us today, and welcome to Smith, Gambrell, and Russell's live webinar called Clearing the Fog, Seeking Clarity in the Workplace and Other Employment Law Developments. Our SGR Labor and Employment attorneys will cover a variety of relevant topics, including cannabis, the Me2 Movement, paid leave, Americans with Disabilities Act, and workplace violence and safety. Today's webinar will be approximately 1 hour. Some of SGR's top labor and employment attorneys will be presenting today's webinar. Patrick Cain from our Los Angeles office will be presenting on cannabis in the workplace. Matthew Clarke from our Atlanta office will speak about sexual harassment and the Me2 movement. Yash Dave from our Jacksonville office will talk about ADA and its implications on websites. Kiyo Kojima in our Atlanta office will discuss proactive measures to take for workplace violence. And Patricia Hill from our Jacksonville office will present on paid leave. Now I'd like to turn it over to Pat Cain to begin.
Hello, everyone. It's a little rainy day here in Los Angeles, but let's get started. Weed, pot, dope, reefer, Mary Jane, grass, bud. There's actually a website that gives you some 1,000 different slang terms for marijuana. But whatever you want to call it, marijuana is in the mainstream, and chances are it's also going to be in your workplace. As of January 1, 2018, recreational marijuana became legal in California. Under a voter initiative, Proposition 64, the Adult Use of Marijuana Act, Californians are now permitted to possess, legally, 28.5 dry grams at any given time. Although personal possession is legal, employers still remain free to enact and enforce workplace policies pertaining to marijuana. More specifically, the new law does not in any way impact the rights and obligations of public and private employers to maintain a drug and alcohol-free workplace. Nor does it require an employer to permit or accommodate, and this is an interesting litany, the use, consumption, possession, transfer, display, transportation, sale, or growth of marijuana in the workplace. I don't suspect anyone's going to hit most of those anytime soon. Also, the law does not affect the ability of employers to have policies prohibiting the use of marijuana by employees and prospective employees, or prevent employers from complying with state and federal law. Remarkably, California was not the first state to legalize recreational marijuana use. In addition to California, 5 other states currently permit recreational use: Colorado, Washington, Oregon, Alaska, and Nevada. In addition, Massachusetts will allow retail sales as of July 1, 2018, and Maine has approved recreational use, but with no particular start date. An even greater number of states, 29 including California, specifically permit the medical use of marijuana, that is, with a doctor's prescription. In California, this dates back to the Compassionate Use Act of 1996. Of the 11 states that permit medical use, 11, Arkansas, Arizona, Connecticut, Delaware, Illinois, Maine, Minnesota, Nevada, New York, Pennsylvania, and Rhode Island, all have laws protecting medical cannabis users from employment discrimination. In California, a similar law is just pending in the legislature. The efficacy of medical marijuana actually has scientific backing. In January 2017, the National Academies of Science, Engineering, and Medicine issued a report finding that marijuana is an effective treatment for chronic pain, nausea, and some symptoms of multiple sclerosis. Nonetheless, marijuana remains a Schedule I regulated drug under the Federal Controlled Substances Act, right alongside LSD and heroin. Moreover, while the Obama administration had issued rules making prosecution of marijuana possession a lower priority, the current administration has withdrawn those rules and has made it clear that the federal authorities intend to prosecute marijuana possession like any other Schedule I possession violation. In the face of these conflicting state and federal schemes, what's an employer to do? Particularly in California, which is where I practice. Surprisingly, for labor and employment laws, there actually are a few clear lines. Also, not surprisingly, there are some areas that aren't quite as clear. Let's start with the easiest case. An employee is not permitted to be under the influence of cannabis at the workplace any more than she or he is permitted to be under the influence of alcohol at the workplace. One complication here is that there's no generally accepted scientific measure for what it means to be under the influence of drugs, including marijuana. Contrast that with alcohol, for which I guess the generally accepted standard is 0.08 or 0.1 blood alcohol content. For marijuana, some states impose a zero tolerance standard. In others, a 5 nanogram concentration of THC per milliliter of blood is a per se level for under the influence. Otherwise, and this applies to marijuana, the test as a practical matter is observation. In what way does the person appear to be under the influence? The current state of marijuana laws in California does not change the drug testing rules here. One little note of caution, be careful. The correct application of these rules can be complicated. But as a general proposition, pre-employment drug testing is permitted across the board so long as it applies in the same way to each position for which testing is required and not in a discriminatory fashion. But testing is permitted only after an offer has been made, so the offer is conditioned on successfully passing the test. Drug testing during employment can be even trickier, but there are a few places where it works. In the first instance, where objective facts create a reasonable suspicion that an employee is under the influence, although as just noted, this can be a little bit subjective. In addition, random drug testing is permitted in the case of safety-sensitive positions, and it's also permitted in the event of a serious accident. In any of these scenarios, a positive test for cannabis can be grounds for adverse action up to and including a refusal to hire or termination of employment. Let's try and get to my next slide. Despite the laws making possession legal, there presently is nothing in the California law that prohibits a negative job action as to a current or prospective employee who tests positive for cannabis use, even if at the time of the test the person is not under the influence, and even if the use is for legal medical purposes. In a 2008 decision, the California Supreme Court upheld an employment termination based on a positive marijuana test. The employee argued that this violated the disability accommodation laws because he was using medical marijuana for pain caused by a back injury. The court concluded that the Compassionate Care Act's reach was limited to the legal availability and use of medical marijuana and provided no other protections, including for employment. In the circumstances, there was no violation of law when the employee was terminated based on a positive test for marijuana. A word of warning here. There is an emerging national trend of authority protecting medical marijuana users from negative employment actions. In August 2017, the Federal District Court in Connecticut found that the refusal to hire a medical marijuana user gave rise to a cause of action under Connecticut state anti-employment discrimination laws. Similarly, in May of 2017, a state court in Rhode Island concluded that the state medical marijuana law gave rise to a cause of action for failure to hire a medical marijuana user. In Massachusetts, where the medical marijuana laws do not include any protection for job issues, the state Supreme Court concluded in July 2017 that failure to accommodate an employee's use of medical marijuana could give rise to a cause of action under the state's anti-discrimination laws. The California legislature just recently, as of February 2018, is considering a similar law, Assembly Bill 2069. This would make it illegal to discriminate on the basis of legitimate medical marijuana use. AB 2069 would not bar negative job action for someone being under the influence at work, even if that involved legitimate medical marijuana use. Also exempted would be employers who are required by contract or license with the federal government to maintain a drug-free workplace. Assuming it becomes law, it is important to understand who and what California's AB 2069 would protect. Only employees or prospective employees who are properly using medical marijuana, and then only if not under the influence in the workplace, with even those protections withdrawn when the current or prospective employer is required under federal rules to maintain a drug-free workplace. AB 2069 would not extend any protection to employees or prospective employees who test positive based on purely recreational use, even though such use would otherwise be legal under California state law. So what's the takeaway from all this, especially for California employers? Seems that there are three. One, there are no protections for being under the influence of marijuana at work, period, full stop. Two, there presently are no protections for testing positive for marijuana use, whether medicinal or recreational. However, three, care should be exercised when considering a negative job action for a positive drug test when the employee or prospective employee can demonstrate a legitimate medical marijuana use. Given the current trend in the law, as well as California's Assembly Bill 2069, it won't be long before some lucky employer gets to be part of the test case for protection for medical marijuana use. Thank you, and I will now turn it over to my partner, Matt Clarke in Atlanta.
Thanks, Pat. Unlike Pat, I'm not going to start off my presentation describing all the various nicknames for my topic. Instead, we'll jump into a discussion of sexual harassment and how the Me Too movement has impacted employers and the workplace. Over the past 6 months, the Me Too movement over social media has provided victims of sexual harassment, both men and women, with an opportunity and a voice to shine a spotlight on those who have harassed them. The movement has grown so quickly and so large that Time magazine, in fact, named the victims of such harassment, the people that had come forward to complain about it, as their Person of the Year, and named those individuals as the silence breakers. And so as a result of the movement, we've seen many different high-profile people be publicly named. Obviously, we've seen Harvey Weinstein, Bill O'Reilly, Matt Lauer, Kevin Spacey, so on and so on, who have been publicly called out. And in addition to those in the entertainment industry, we have seen many in politics, many in business, and many throughout corporate America be called out for this. So what are we seeing as some of the impacts from this Me Too movement? Well, there's obviously been more discussion and focus. We've seen an increased willingness of victims to report. We've seen more employers imposing real and severe consequences for people found to have engaged in harassment. We've seen a much greater increase in social media and regular mainstream media reporting on this. We've also seen more employees who are former employees sort of coming out of the woodwork, people who may have been gone from a job for a year, 2 years, 5 years, coming back and telling their former employers, hey, I never said anything while I was there, but I want you to know now that Joe Blow, Sam Smith, whoever was harassing me while I'm there, you have a harasser in your midst and you ought to do something about it. You would think that as a result of this, that we would have seen a large increase in the number of lawsuits and EEOC charges filed. I read an interview last week with the head of the EEOC who said that so far they have not actually seen any market increase in the number of filings, but they're anticipating it. And that a number of the insurance companies and employers who've been receiving demand letters and lawyer threat letters and whatnot have really increased dramatically over the past couple of months. So the expectation is we're going to see an uptick in the number of actual claims filed. As a result of this heightened focus on sexual harassment, many employers and the people who work there have been turning internally and asking themselves, what are we as a company doing to address this? Do we at our company have a problem? Ought we be doing something? Should we sit back and wait, or should we be more proactive and be doing something? This movement has certainly caused the sort of traditional thinking and questions on harassment to be turned on their head. Typically and historically, we've seen a lot of people have the attitude that, hey, we all kind of know where the line is, what harassment is and isn't. We all sort of should know what is happen if somebody feels they've been harassed or if they feel like they've been discriminated against and what they need to do. But that is not necessarily the case anymore. And surveys have sort of borne that out. On the screen is an example of a survey from October of 740 women across the country. And in that particular survey, 30% of them said that they themselves had experienced sexual harassment. I've seen others say that I've seen other surveys that had higher percentages even than that. About a quarter of the people said they had been harassed by men, and 95% of the women in this particular survey said the male harassers they felt usually went unpunished. A similar survey was held last fall with a nationwide group of men, and it would be nice if the slide wouldn't advance tenfold. Goodness gracious, sorry folks. And we're there. In this particular nationwide survey of men, about a third said they didn't think catcalling was sexual harassment, and 2/3 of the men surveyed said they didn't think that repeated unwanted invitations to drinks or dinner or dates was sexual harassment. About a quarter of them said they themselves had been harassed at some point. 20% or so said they didn't think sexual harassment would be a fireable offense. And about a quarter of these men who were surveyed said they thought that all of the focus on this was not justified, that it was not warranted. The movement has caused people to also move beyond sort of historical stereotypes. We've seen more females being named as harassers. We've seen more individuals accuse people of the same sex of harassment, and it's caused many employers to rethink the consensual relationships within the workplace, because they've recognized that when such relationships go south, it can certainly cause problems. So more and more employers have put into place policies that, for example, prohibit romantic relationships between people who are in a reporting hierarchy. And some employers will even say if coworkers who are on an equal level are dating, we want them to sign off on something, sometimes called a love contract, where the employees acknowledge that this is all willing and voluntary and that the employer is not causing this and they're good with everything. When people do file claims, the legal inquiry is, did the employer exercise reasonable care to prevent and to correct promptly any sexually harassing behavior? Well, how does an employer prevent that type of harassment? Well, the first step is to see if the employer has a policy. Do they have an appropriate, adequate policy? And more employers are now going back and revisiting their policies and looking at them to see, is our policy detailed enough? Is it understandable? Can people tell by reading it what is and isn't harassment, where to go if they have a problem, and who they should go to, and to make sure those policies have language that says the person who complains won't be retaliated against. Now, another thing to consider is the idea of training. To be frank and blunt, too many employers probably treat sexual harassment and other discrimination and harassment training as something that's sort of a pro forma thing that gets done as part of a new employee's initial orientation. HR checks off on the box that it was done, sticks the form in the drawer, and that's the end of it. But more employers have realized, you know, that's not enough. We need to do more, and we're going to have more periodic, maybe even annual training to make sure our employees know what to do. We're going to redistribute our policy and have people go back through updated training to make sure that everybody's a little bit more on the same page. Because historically, too many times when people would complain about harassment or raise an issue, the employer's sort of default response was, well, you know, that's just Jim. That's just the way he is. He doesn't mean anything by it. Just brush it off. Well, that was the reaction that too many employers have had. That was the reaction that employers had for Harvey and Bill and Matt, all of these high-profile people who the employers thought, well, that's just his way and everybody's fine with it, but that's not going to cut it anymore. And more employers are realizing that it's especially important when members of upper management are charged with being harassers, that a company needs to take very careful steps. As a practical matter, if HR, for example, usually investigates harassment complaints, but the head of HR reports to the CEO or the executive who's accused of harassment, people naturally are going to ask, well, how independent is that investigation? Or is the person just trying to protect their own neck? So more companies have started getting outside investigators, third parties to come in, or maybe even the board of directors may appoint a special committee to investigate things when a high-level person is accused. One thing to keep in mind, and this has just historically always been the case, is when you combine darkness and alcohol with your employees, bad things tend to happen, and employees will go off to happy hours or conventions or trade shows or parties or whatnot, and they forget that if you're still around coworkers and you cross a line, it still matters. And the things that people say and do in those sorts of environments very much can create problematic behavior and lead to claims. Another thing to keep in mind is a lot of companies have sort of this kumbaya attitude, or they have really nice written policies that say all the right things, but you have to ask yourself, okay, if I'm being objective, is this really accurate? Do we actually sort of practice what we preach in this regard? You know, we may say we don't tolerate things, but yet we know that managers are going around making dirty jokes or saying inappropriate things in the workplace. That's inconsistent and not good. You obviously need to train managers so that they know themselves what to do if they receive a harassment complaint. And the hint here is it's not always so obvious that an employee is complaining about harassment. Rarely does someone walk in with a big notarized piece of paper that officially proclaims harassment complaint at the top. A lot of times these things start from much more understated comments, you know, just an employee telling someone else, oh yeah, Jim's being nasty with us today, or he's being a bad boy, or something like that, that people sort of laugh off. Well, you may need to pull that person aside later and say, you know, hey, I want to circle back with you when you mention that. What's going on? Is there a problem? A few other additional things to consider to be proactive in this area. Many employers have decided that they will do surveys of their workforce to see if there is indeed a problem. You can even do anonymous surveys asking employees, do you think we have a problem? Do you feel like you've been subjected to harassment? Have you seen others? That will give you an idea whether your workplace is one where there's perhaps more problems going on than you realize. Many companies have put into place reporting hotlines that people can call. That's particularly helpful for companies where your workers are dispersed at various locations throughout the state or the country, where they may not necessarily be in the office where HR is, and they don't feel comfortable reporting to the person who is in charge of their particular location, since that person might be the harasser or might be friends with the harasser, so to speak. And finally, in terms of training, I think it's a good idea to give heightened training to managers and supervisors, to give extra emphasis to them as to their obligations, how they need to proactively look for these things, and they need to react when they learn of harassment or see it in the workplace. And even HR personnel need to be properly trained to know how to investigate, what to do when they hear of a complaint, what do they need to be doing in terms of interviewing the victim, interviewing witnesses, and those things. And finally, many companies who do have sexual harassment policies, it might just be a sentence or a paragraph in the employee handbook, and not all companies make those policies perhaps as accessible to employees as they should. Sometimes the master handbook may just be on a shelf or in a drawer in HR's office or a manager's office, and it takes some amount of effort by the employee to access it. It's more helpful if you can broaden your scope of that and make it easier for employees to access it, either by giving them all hard copies themselves, putting it online, putting it on your intranet, and things of that nature. Very evolving area, to be sure. So with that, we will move on now, and Yash is going to speak about some issues with the ADA. Thank you.
Looks like we're having just a little bit of technical difficulties. Hold on one second.
All right, I hope everybody can hear me now. Again, I'll be talking to you about the ADA compliance and how to make your websites ADA compliant. I believe everyone is familiar with Title I of the ADA, specifically dealing with non-discrimination against qualified individuals with disabilities in employment situations. What I'd like to talk about today is Title III of the ADA, which applies to places of public accommodation. So starting with that, Title III basically provides the general rule is that no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, and privileges of any place of public accommodation by any person who owns, leases, or operates a place of public accommodation. And so what this basically requires is that all places of public accommodation provide equal access to their goods and services to individuals with disabilities. Now, litigants are successfully bringing these ADA suits against Title III entities on claims that their websites are not reasonably accessible to those with disabilities. And so how do we get here? Well, in 2017, there were over 7,600 lawsuits that were filed under the ADA across the country. And these include both physical barriers to places of public accommodation and website inaccessibility issues. And of those 7,600 lawsuits, over 800 of them alleged inaccessible websites. New York and Florida led the way with more than 335 and 325 cases respectively. And there's some honorable mention for California at 115 cases and Georgia with 9. But as you can see, this is a growing area of litigation. We saw a 16% increase in the number of lawsuits from 2016 to 2017. And what you have up on your screen right now is a recent decision from last year from down in Miami. And this was the first federal court decision that issued a verdict finding that Winn-Dixie violated Title III of the ADA by having a website that was not usable or accessible by disabled plaintiffs. And in this situation, the plaintiff here wished to download coupons, order prescriptions, and find store locations. And the court held that the website and Winn-Dixie specifically violated Title III of the ADA. And importantly, the judge rejected Winn-Dixie's undue burden argument that it would cost $250,000 to make the website accessible. Okay. All right, so I'd like to mention a little bit about the history of the regulation. So in 2010, the Department of Justice, which is charged with enforcing the Title III of the ADA, released an advance notice of proposed rulemaking stating that it would be seeking to publish regulations on the applicability of the ADA to websites of Title III entities. And in 2015, the Department of Justice, without actually issuing any regulations, took the position that the ADA does apply to websites. And it also proposed some guidance on the standard to be applied to website, and that was specifically the what's called the WCAG, or the Web Content Accessibility Guidelines 2.0, Level 2A. That was the last pronouncement from the Department of Justice regarding any type of regulations that would be forthcoming. And in 2017, in July, after the new administration took over, the Department of Justice decided to place that rulemaking on its inactive list. And it decided we're going to put this in the back burner, we'll get to it eventually. But in December, the Department of Justice finally withdrew that advance notice that was issued in 2010, and essentially stated that we're not going to issue any regulations at this time, but we will evaluate whether any regulations about website accessibility is necessary and appropriate. I'm trying to advance the slides here. Okay. So without any regulations, now what? What do we do? Well, the covered entities cannot rely on the absence of applicable regulations. The Department of Justice has stated in court filings that it considers websites to already be covered by the ADA's general requirement of ensuring full and equal enjoyment of their goods and services. So as a result of the lack of regulations, it has led to more litigation and sometimes inconsistent court decisions. And you'll see here that we have a patchwork of decisions out there, but out of this patchwork, 4 views have emerged regarding the ADA's applicability to websites. And the first view is essentially that the internet is simply not a place of public accommodation, and that Title VII restricts its coverage to physical places of public accommodation. This is somewhat of the minority view. The second view out there is that the internet itself is a place of public accommodation, and a business, whether in physical or electronic space, cannot exclude disabled persons of full and equal enjoyment. Again, not a prevailing view, but one of the views that have come out. The third and fourth views are the more of the prevailing views, and this is where we have some inconsistent decisions. The third view essentially states that the website must have a significant nexus with the entity's physical location to be covered by the ADA. And what this essentially does is takes a 2-step approach. First, it determines if a Title III place of public accommodation is involved. And then if it is, then it assesses whether a nexus exists between the complained of event and the physical place of public accommodation. And this was the view that was adopted in the Winn-Dixie case we talked about earlier. In that situation, the court found that Winn-Dixie's website had a significant nexus with its physical locations. Specifically, customers could go on their website, download coupons, order prescriptions to be picked up in the stores, and as such, there was a significant nexus between the website and the physical location. And then finally, we have a fourth view, and that basically states that businesses are places of public accommodation if they are exclusively internet, doing what places of public accommodations listed in the ADA would be doing if they were in physical spaces. And this court here, this case against Netflix, the court stated that that the ADA is meant to evolve with technology. And the ADA covers services of a place of public accommodation, not at or in. And so because it covers the services of, Netflix, even though it provides services exclusively on the internet, can still be considered place of public accommodation. And it's no different than your Blockbusters or your movie rental places with brick and mortar stores. And because it's providing those type of services that a place of public accommodation would provide, it is covered by the ADA. So what's the bottom line? Well, if you are a Title III entity, if you have a brick and mortar place, it is time to make sure that your website affords full and equal enjoyment to all persons, regardless of any disability. And this includes not only your website, but also your social media, your mobile applications, and any other electronic content that is available from the company. So how do you do this? What are the standards? So as I mentioned earlier, there are no regulations out there. But the courts and the Department of Justice have come out and said that, well, this WCAG 2.0 Level 2A standard is the standard that we're going to follow. And this standard looks at accessibility of websites through 4 lenses. First, it has to be perceivable. The information and the user interface components must be presentable to users in a way they can perceive it. It must be operational. The user interface or component and navigation must be operable. It must be understandable, meaning that the information and operation of user interface must be understandable. And then finally, it must be robust. The content must be robust enough that it can be interpreted by assistive technologies. And so what I have here are some tips for you to use when creating accessible websites. One is to have clear font types. This is very important for screen readers. Ensuring that your website has a high contrast theme, which will help visually impaired people navigate your websites. Having a skip to main content link is helpful for people who cannot use a mouse to navigate a website, and they can do so with a keyboard. Alternative text or HTML headings. These are essentially text of images so that they can be read by screen readers, and then the image descriptions also can be read by screen readers. Video closed captioning is necessary for deaf and hard of hearing users. And then finally, audio descriptions help visually impaired individuals visualize the videos or images to get a more complete picture of what's on your website. So these are just a few tips on getting your websites in compliance. There's a whole host of resources that are available on the World Wide Web Consortium's website, and I have that up on the screen. And the World Wide Web Consortium is the entity that published these WCAG guidelines. Additionally, there are many third-party vendors that provide audit and certification services, which ensure that a website at the time that it is tested is compliant with the applicable standards. And then finally, the consortium also has a compliance badge that is available that you could use to place on your website, which basically, it does not indicate that an audit had been completed, but if your website is compliant, you could use that website, that badge to post on your website. And so with that, I will turn it over to my partner, Kiyo Kojima in Atlanta.
Thank you, Yash. Can everybody hear me okay? Well, I guess only the panelists can chime in, but let's see. Okay, well, I'm Kiyo Kojima. I'm located here in Atlanta, and I have the honor today of speaking with you about what is not entirely all legal. What I mean by not all law is what I'm trying to say. My topic here, I think, encompasses sort of a hodgepodge of common sense vigilance, HR, criminal law, employment law, insurance, whatnot. I mean, whatever it takes to keep the workplace safe. So let's just begin here. Like the Me2 movement that we talked about before, I think safety in general is very much on the forefront of on people's minds these days, with mass shootings that seem to occur way too often, and of course beyond that, just workplace, whether it be within the workplace or a friend or relative of an employee, as the case may be. So, I mean, some not typical, but recent media reports here. 60-year-old man entered his workplace, pulled out a gun, shot his supervisor. Yes, the perpetrator didn't have criminal history. We didn't know what prompted it. I mean, sort of the worst case scenario. We don't know why, we don't know who, and there was no background or anything in the past that would have indicated something like this could happen. Second example, Jared the Galleria of Jewelry. So, armed robber entered into a store, confronted by an armed security guard. So, yeah, this, I mean, second example, a little bit more, how should I say this, understandable in the sense that, hey, armed robberies occur. So we can talk about what to do with your premises or safeguards you can take. Third example. So this, of course, two employees have an argument. One person pulls out a gun, shoots the other. Shooter had a criminal background. So in the scale of things, first one being sort of most mystifying, second one, wrong place at the wrong time, as it were. Third one, perhaps something that could have been prevented with a proper background check, and something about just being vigilant about what's going on at your workplace. I'm having a bit of a difficulty moving the slide. Liz, can you help me out?
Yes, Kiyo, just tell me when to go to the next slide and I'll do it for you.
Appreciate it. Go ahead.
Actually, 1 second. I'm trying to get the control back. 1 second.
Yeah, so essentially, while Liz is working her magic, the stuff I'm going to talk about today, if you're rolling your eyes saying, yes, I already know all that, that's good. That's good. I like that, because you're already doing the right things, right? If you're hearing it again, that's fantastic. I grew up playing an instrument, so that means I like having things repeated, or I like having to repeat things 500 times a day. But so here are the statistics, though. We hear all the time in the news after bad things happen that things are safer than ever. But here are the sort of the stats here. 80% of active shooter incidents occur in the workplace. Right? That's sort of frightening when you think about it. 2 million people a year are affected by workplace violence. 50% of workplace violence happens in a public environment. Estimated cost of workplace homicide, $800,000. That's for a single occurrence. And 27%, more than 1/4 of businesses have experienced at least one violent workplace incident in the last 5 years. I myself had just had one this morning where, go ahead, let's move to the next one. Where an employee came in and went into a private space and committed suicide. Not violence per se, but or violence onto oneself. But these things do happen. More comments about trends, not always about work-related issues. So, a wise person once told me that being an HR manager is like being a teacher, a boss, a mother or a father, a guardian. all at the same time. I fully recommend you try to get to know your workers as much as possible, depending on the size of your workforce, of course. But generally, when things happen and you call us, or the likes of us, the lawyers, our questions are always like, hey, you know, so was she or he married, or what was the family situation like? How many kids? How old are they? Were they having any difficulties? They're just human aspects of employment law. Disgruntled workers, not necessarily the culprits. Two-thirds of the workplace homicide attackers not known to have personal relationships with victims. And key point here, the third point, assailants who are most assailants who are employees commit workplace violence due to something else going on in their lives. Yes. Go ahead, Liz, thanks. I can't tell you how often I get calls because employees' boyfriend or girlfriend, or you know, would gained access to premises, and you know, somebody discovers that person and says, "Wait, who are you?" So, you know, basically, what can we do from an HR standpoint? Here's a list here, and I have it listed in more detail, perhaps more than the time allotted, time would allow. So if you're having trouble falling asleep one of these nights, you can put through these slides here. So background checks, that's an obvious one. Identifying signals of stress or danger from employees. Training employees to make sure they're aware, they're more aware of what's going on and get along. Controlling access, we already talked about that, gates, security cards, response team, security guard, emergency hotline. Go ahead, Liz, thank you. Oh, there we go, did I just move that? Nope, go ahead, keep going. So, sorry, can we go back to that? So yeah, this background check slide 1 and 2 just talks about, you know, typical example of what not to do, because these turned out to be lawsuits. Yes, I'm a firm believer that #1 rule of running a business is not getting sued to the extent possible. So yeah, you can go ahead, Liz. Thanks. So I can't stress enough, doing background checks, criminal records, credit reports, medical conditions and treatments, financial circumstances, family structures, et cetera, et cetera. You know, please make sure you use the proper Fair Credit Reporting Act forms. Make sure you have proper authority to do the background check, and you know, make sure if you're going to act on the information that you gathered, please follow the Fair Credit Reporting Act requirements, or the state equivalent. And these seasoned HR professionals, you probably already know. If you're witnessing employees who appear or act confused or frustrated or constantly blaming the company or co-workers, then yeah, I think those all warrant a chat at a minimum, I think. Go ahead, Liz. Oh yeah, so same thing with anger, hostility here. Going on. So elaborating on the initial list that we mentioned earlier, with a bunch of question marks, external, internal links, risks. You know, should you provide escorts? When somebody, especially, there was a mention of dark places earlier, with or without alcohol. You know, make sure that those persons in those circumstances are secure, controlling access, maintaining good lighting, video monitoring. I mean, to what extent do you want to monitor? We had a situation where employees were being monitored in the restrooms. Let's not do that. Surveys, training. Go ahead, Liz. Policies. We draft all kinds of policies here, but obviously policies preventing well, policies for dispute resolution, policy for zero tolerance conduct, preventing harassment. Obviously, harassment breeds disgruntlement and conflict, and that could escalate very easily to unfortunate circumstances. Encouraging everyone to emphasizing quality of relationships, encouraging everyone to report incidents of violence or potential instances. So, not to make it sound too much of like, singing Kumbaya around the fireplace, but I think making sure everybody's getting along is very important, I think, to an effective workplace. So along the same lines, effective lines of communications, no reprisal or retaliation, and considering hotlines. I know there was a mention of outside investigators earlier, but third-party hotlines, I think, is very useful as well. So in controlling access, we talked about this earlier, gates, sign-in, visitor badges, parking lot monitoring, cameras in general. Lately, I've been witnessing a lot of very impressive electronic, strictly computer-based sign-in system where you enter your name, email, phone number, who you're going to see. They print out a sticker for you and everything. So that we can put you in touch with those vendors too if necessary. So these bits, the legal bits, like I said, if you're ever having trouble falling asleep at night, please look over them. But as you can imagine, a whole host of different agencies want to have their hands in it. EEOC, obviously, the FTC, OSHA, of course, is another big one. So, and hopefully we don't get into a situation where we need to, where these regulations become relevant. But if it ever does, then, here they are. Go ahead. Yep, thank you. So OSHA general duty clause. Oh, that's okay. In the interest of time here, I'll just sort of briefly mention that again. OSHA governs. OSHA has a hand in it in this too. EEOC, the harassment stuff I bring in here because harassment often leads to workplace violence. So another reason why you should be vigilant and to nip things in the bud if you witness it or if you know of it or should have known about it. But I'm sure it was mentioned before, so let's move on. Okay, not to beat a dead horse here, but again, clear written policy that is well known throughout the company about harassment, violence, hostility, getting along, and also dispute resolution, and providing training on those points. Thanks, Liz. Swift, consistent justice, yes. If you have a policy and you have employees violating it, please make sure you're enforcing it. I realize all of these things were mentioned before, but I can't say enough how important this is. But also I realize too how difficult it is to do this. So again, the vigilance I think is very important. Next, please. So these are typical responses to violent behavior. Isolate and secure the work area, call 911, seek medical attention. I mean, common sense things, but sometimes it fails to get done. Incident reports, very important to do so very shortly thereafter. Get multiple witnesses if possible, get witness statements, multiple if possible. Provide employee assistance, referrals to programs. Thank you, go on. Oh. So yeah, sorry, I realized that was very quick, but might have run over a little bit. Sorry about that, Patricia.
Hi, this is Pat Hill. I'm in the Jacksonville office, and I am going to hopefully be presenting materials regarding paid leave.
Pat, I think there's a little bit of delay. It may take you a second to be able to scoot.
Okay, thank you. there has been a trend over the past few years of an increase at the state and local levels of being required to have paid leaves. Now, if I can ever get my slides to move, but I do want all of you attendees to know that we are going to be sending out after this presentation a chart of all of the current state paid leave laws and also some of the local paid leaves. Now, for some of you, it's going to be very important that you, if you have government contracts, that you know that Executive Order 13706 requires paid sick leave for workers who are federal contractors. And this applies to every contract and subcontract that is effective on or after January 1st, 2017. Now, this is going to include your contracts covered by Davis-Bacon, the Service Contract Act, the concessions contracts, and contracts in connection with federal property or lands. This statute requires that an employee must accrue a minimum of 1 hour of paid sick leave for every 30 hours worked on or in connection with a covered contract. This statute also requires a cap of 56 hours per year, and the employee may carry over any unused amount, but the carryover does not count towards any annual accrual limit. What has been the employers in the United States response to the paid leaves? Well, there are lots of companies that are now paying maternity leave, and a lot of them are at the tech companies. For example, Netflix, that has had a big success with Stranger Things, is able to afford to pay 52 weeks of maternity leave. Microsoft is at 22 weeks, Twitter 20, and Amazon at 20. Now, for paid family leaves, and we get asked about this by clients a lot, should they be paying for family leave or should they be paying for maternity or paternity leave? And we have found that approximately 5% of all companies in the United States offer fully paid maternity leave. On average, the top companies in the United States offer 8 weeks of full paid maternity leave. And on average, 18% of the companies in the United States offer paid paternity leave. Now, I'm going to very briefly go over a couple of the state requirements for paid leave. New York currently requires paid family leave, but it's funded by employee deductions through the workers' compensation system. A little different than a lot of other states. Maryland now requires paid sick leave, and Austin, Texas, some of you may have heard about this, requires sick pay. However, the state legislators aren't happy with Austin regarding that, and they have vowed to pass a law striking it down. You will see on the chart that will be sent out after the presentation a little bit about what the legislators are trying to do. Be aware that a lot of local ordinances, counties, cities, villages, and at the state level, there are a lot of bills pending right now in the legislators. And at the federal level, there is a bill in the House that is going to amend ERISA, and it's going to preempt the application of any of these state and local laws regarding paid leave. You employers should be aware, if you do have any type of paid leave, if you hand that over to third-party administrators, that you, the employer, will be responsible for making sure that the third-party administrator handles it properly. The Department of Labor, if they're going to do an audit of your company, will ask for all the documents used by that third-party administrator. So what you as employers must do is to be sure that maybe have your own internal audit of your third-party administrator to make sure the leaves are being applied correctly and consistently with your policy. Also make sure that your frontline managers and supervisors recognize what the employees are asking for, or maybe not even asking for. Sort of like with FMLA, a lot of times you hear about the need for FMLA for a frontline employee from the person's supervisor. Well, the same thing applies, that you need to tell your managers and supervisors, hey, if you know about a need or a request for leave, make sure that goes to the third-party administrator. And be careful about the different types of information requests that you may get for an FMLA leave versus short-term disability versus anything to do with these paid leaves. Now, my one piece of advice is be careful out there. The laws are very complex. They are sometimes contradictory. You will see that when you compare FMLA information that you can get versus what you're permitted to ask about for these different paid leaves. And stay informed about the new paid sick leave laws and your obligations regarding them. Thank you very much. And now we're going to open up this session to any questions that you, the attendees, have.
I think I see one question from Leela. What was the problem with the customer not being able to access the site? I think that must be for Yash.
Sure. I think I believe that comment or that question was relating to the Winn-Dixie Stores web case, and if that's what we're talking about here, the plaintiff in that case was visually impaired, he was legally blind, and could not. He used a computer but could not see the screen, and he used a screen reader software which would automatically tell him what is going on the website, and he used a keyboard instead of a mouse to navigate a website. And the allegations allege that when the plaintiff attempted to access the website, some of the tabs did not work. Approximately 90% of them did not work. He could not use his screen reader software to read what was on the site because the website was not compatible with the screen reader. And essentially he was unable to navigate the website as a result, and that was the issue with Winn-Dixie's website.
Okay. Feel free to type in a question in the Q&A tab if you have a question. See, there might be one more question. Can we send this PowerPoint out to participants? Yes, we will absolutely send this PowerPoint presentation out to everyone in attendance. Matt, I think this one's for you. Melanie Miller asks, regarding current harassment conditions, what behaviors are companies suggesting to prohibit more HWE situations?
Hi, I'm here trying to access that. Melanie, there's in general, companies, to be honest, have started cracking down on all sorts of things. We are trying to make sure that companies are vigilant in every regard, and so they are trying to, certainly make sure that what their policies are both in effect and being followed, and that the companies, have people who are being vigilant on the ground. So I don't know that there's any one particular thing that I'm seeing, but I think all of these are good advice, all the things we talked about during the main part of the presentation.
Okay, Yash, I think there's one more for you. Kim Pastor says, what's the likelihood of this ADA website accessibility applying to a small business? It sounds very expensive to convert your entire website to comply.
All right, thank you for the question. So there is a, if you're a place of public accommodation, regardless of whether you're a small business or a large business, you are subject to the Title III of the ADA. I have personally known of many small businesses that have faced these lawsuits, from mom and pop restaurants to dentist offices. And so regardless of the size of your business, depending on where you're located and what the current state of the law is in your state, it's advisable to have your website audited by a third party to ensure that it is accessible. There are very few courts out there that take the position that the ADA does not apply to websites. The prevailing view now is that it does apply. And as I mentioned, it's either the third or the fourth view. And so if there's a nexus to your site, to your physical location, you should certainly make sure that your website is in compliance.
Okay, I think this one is for Pat Cain. We have a third-party warehouse in California. Should we ask for their handbook to see their policies regarding drugs and alcohol?
Hopefully I've unmuted myself so people can hear me.
We can hear you.
Good. Yes, when you say a third-party warehouse, I think in part it's going to depend on what your relationship with them is. There's an issue about control of the like. Maybe you want to, but if you don't control them and it's their own operation, I don't think that there's any need for you to look at their handbook. You do want to look at your own handbook, and you do want to understand the intricacies of the drug testing laws, particularly in California. As I said during the presentation, you can test pre-employment if it's across the board and non-discriminatory, but it has to be with an offer pending. It gets much trickier to test current employees.
Okay, Yash, I think you have another one. Concerning websites, online applications for manufacturing, would the same apply? I'm listening to you about size, but the employee must meet certain criteria for employment.
So if I understand their question correctly regarding the comment about employees must meet certain criteria for employment, obviously Title I, which applies to employers, it applies to employers with 15 or more employees. Title III of the ADA applies to all places of public accommodation, regardless of the number of employees you have. And it would apply to a manufacturer's website if, again, the views out there are that if you provide services online that are similar to the services that a brick and mortar place of public accommodation provides, then you are very likely subject to Title III and your website has to be in compliance. But Title III takes a very broad definition of what is a place of public accommodation. I mean, it essentially includes most, if not all, brick and mortar businesses, whether they're providing goods or services. And so a manufacturing facility, if it is open to the public, it would be a place of public accommodation, and as such, its website would also constitute a place of public accommodation.
Great. Pat Cain, I think this one's for you. I have locations all over the U.S. Should we have a separate employee handbook for California employees?
The short answer is yes. there are a number of requirements in California that don't exist under federal law and certainly don't exist under other states' laws. The anti-harassment provisions in California are somewhat broader. The requirements for what you have to provide to employees is different. So yes, you should have your handbook looked at for compliance with California law. In addition, in sort of verging into Patricia's wage and hour issues, and in California, there is just a mind-numbing patchwork of different requirements for paid time off. They exist at the city level. They exist at the county level. They certainly exist at the state level, but just for my own practice, there are, a dozen or more cities, separate cities in the county of Los Angeles, and you have to make sure you're complying with their paid time off requirements as well. So yes, your handbook for California employees does have to be California compliant.
Okay, great. We have another one. I think Pat Hill, this one's for you. If you already give PTO, do you have to give additional paid sick leave over and above that?
You will have to look at the requirements for the paid sick leave that you're looking at, whether it's at the state level or the county or the city level, and determine whether your PTO policy and practice complies with it. It's very possible, and a lot of our clients are finding this out, that you have to make changes to it in order to comply with the law.
Okay, we have in writing policies, is it best presented individually or several at one time in a meeting to sign off on? I'm not sure who's best to answer that.
I'll make a stab at it, and anyone else can jump in on it. You can do whatever you want with your policies as to whether you want to wait until there's a handbook or whether you want to draft a policy based on a situation that you had and you want people to sign off on. But definitely present it to the individuals and have them sign off on it. Give them the time to read it. If you put it in a brand new handbook, give them the paid time at the work location to read that handbook, not just say sign this and read it at home. No, have them read it at the workplace and sign off on it.
Okay, and I think this is the last question. We've had a lot of good questions, so let's make this the last one. How do you handle leave for an employee who has exhausted leave under the FMLA or is not eligible for FMLA when the ADA is not a leave law and the courts have started recognizing that, but the EEOC pushes leave as an accommodation under the ADA? No state FMLA exists.
All right, I can address that, and anyone else on the panel can jump in if they want to. But the EEOC definitely is pushing leave as an accommodation under the ADA, and a lot of courts are also looking at that. It's not an open-ended leave. It's not something that can go on forever. But yes, some sort of leave, perhaps unpaid leave if you don't have anything under the state, city, county laws, but then you can give them a leave under the ADA.
This is Pat in California. I can tell you that there are California decisions that specifically hold that some amount of leave, not open-ended, but some amount of leave can be considered a reasonable accommodation under the Fair Employment and Housing Act, the state version of FMLA and the ADA.
Okay, and it looks like we had one last question sneak in here. We'll go ahead and take it. We have an employee who was injured outside of work. She is out on FMLA now, will likely be on long-term disability. She's in a coma, severe brain injury. Owner wants to continue her employer paid benefits indefinitely. Is this a good idea?
All right, I'll jump in on this one. Just remember that no good deed goes unpunished. If you do it for you do it for this individual, the next person who has hopefully not this horrible situation, but needs some additional paid benefits for a fairly long period of time, and you deny it, you're going to have to answer the question, why did that person get it, but I didn't? Is it because I'm over the age of 40? Is it because I wasn't your good hunting buddy before this horrible accident? Things like that. You just have to really evaluate it very carefully.
That's absolutely right. That's what I tell clients. If you're going to do it for this person, you better be sure that you're willing to do exactly the same thing for maybe the employee that's a bit more of an issue for you. The other thing to consider is the terms of the disability insurance or the medical benefits policy. It may require that people actually be working. And so if you're going to try to extend something, you also want to make sure that the insurer is going to be comfortable with that.
Okay, great. I think that's it for questions. So thanks everybody for joining us. If you want to receive CLE credit, please complete the survey in our follow-up email that we'll send tomorrow with your name, state, and bar number, and we'll get that sent in. And we'll send all attendees HRCI and SHRM credit information tomorrow as well in a follow-up email. And lastly, if I can move. Here we go. We have our annual Workplace Labor Employment Seminar coming up soon. We're going to have it in Atlanta, Jacksonville, and Los Angeles. The date for Atlanta is May 3rd. Jacksonville's date is May 8th. And LA, we haven't picked a date yet, but it'll be coming probably in June. This is a half-day seminar, and it will include topics similar to today's, but more in depth on employment law, labor law, immigration, healthcare, OSHA, and ERISA issues. The theme this year is Workplace 2018, Navigating the Changes in Labor and Employment Law, and all the seminars offer CLE and HRCI and SHRM credits. So for more information on any upcoming webinars or events, you can visit our website at sgrlaw.com. And that is all. So everyone have a great day. Thanks.